Hi there. Obviously, the prevalence now for hearings in the civil courts is for those to be done remotely, either by telephone or by Skype for Business. That being said, I thought I'd do a short video about the bundles that should be created in an ideal world for the judges to use in those hearings. Firstly, don't assume that the judge will have the court file. A lot of judges are working from home at the moment. Even if they're at court, there's a skeleton crew, and so it might not be possible for the judge to have access to the full hard copy court papers. So number two, make sure that all of the papers that you want the judge to see and the other side want the judge to see are all within that bundle and all filed at once. Historically, an application might be made, then a witness statement filed and served. Short time after that, one in response to that, a little bit of extra evidence, all done in a piecemeal fashion. Even if that's happened in your case now, the bundle should contain everything that you need, and it should all be filed at once in one document. For PDF mergers, I use ilovepdf.com. Super simple web page, opens up in your browser. Just download your PDFs into it, we'll merge it all together. You can upload it back up to your laptop after that. That will probably create a fairly large PDF, even for simple interim hearings and applications. And so number three, file it using a file sharing system. Mimecast is the one that I use most often, and that those who instruct me use most prevalently. I'll insert a link to that in the box below. Number four, don't duplicate documents. So I'm going to come on to at number five, what ideally you would have in the bundle. In the application itself, there is likely to be pleadings, experts' reports possibly, exhibits, correspondence, emails, etc. If there's a statement in opposition, there's likely to be exhibits to that. There might even be pleadings as well. And if you add in the pleadings, then add in the application, then add in the statement in response, it might be that there's 3 or perhaps even 4 sets of pleadings. If there's a second application, that might append the first application. And I had that in a case last week. It was a half-an-hour application. It was 400 pages because the pleadings were in there, the first application, the second application, which appended the first application, etc., etc. So fillet your papers and put in the application, put in the witness statement, and take out everything else. And then you can put the bundle in the correct order. And so number 5, put it in the correct order. My suggestion, there's no hard and fast rules here, but my suggestion would be a short case summary. That doesn't need to be a case summary for trial, but simply this is a breach of contract claim, contract entered into on so-and-so date, allegations of breach on so-and-so date, claim is for specific performance or damages totaling X amount, and the application is for a declaration of so-and-so. And here's the draft order. Then the pleadings, so particular claim, defence, reply, schedules, counter schedules, they go in. If they're in the application, this is the time to take it out of the application. So have the pleadings first, then after the pleadings would be the court orders. They're really useful, especially if they're chronologically from first to last. Really helps someone come into a file just to get a feel for what's happened in the case. The procedural history, often in interim applications, is important. So orders there, they can be before the pleadings or after. I would be fairly relaxed about that. After that, the application or the draft order that's being asked for, then the witness statement in support, witness statement in opposition, and then at the end, exhibits. Now, the reason I say take the exhibits out of the witness statements, I say that if there's more than one. But I say it because there's often correspondence which either conflicts or is mentioned in one statement but not mentioned in another. If you have it all in one place, much easier for the advocate on the day to say, right, we're going to look at these exhibits, because the judge doesn't actually mind in the vast majority of cases. The judge doesn't mind who's produced a letter, as long as it's agreed that that letter was sent and or received. So it doesn't matter whose witness statement in reality was appended to. The judge just wants the evidence, and it will help the advocate go through the bundle, go through the case chronologically, because often once you're into the exhibits, you're cross-referencing exhibits as opposed to going back to the witness statement and back to the exhibit. So I would have the exhibits at the back. A little point about emails. If there's email chains going to and from, just post the final email chain, which will have all of the responses in. What sometimes happens is you get an email, then they exhibit the response, which has the original email, then the response to that, which has the two previous, etc. You end up with 50 pages that actually only totals 12 emails, 12 short emails, but first email is repeated 12 times. So try, if possible, to fill it that. There's an excellent PDF editor, PDF Expert. I'll put a link to that. You can use that on your iPad, on your laptop, on your phone. That's really good for just taking pages out and then merging them back together. Following on from exhibits, cost schedules, anything arising out of that. Have a think about whether you need your expert's report in there. If nothing turns on the expert's report, then you don't need the 50 pages. If something might turn on it, then it needs to be in there. If there's reference to Part 18 questions, if there's applications for specific disclosure based on some evidence that's in the report, etc., then clearly the judge is going to need to read that report, or at least be able to go to it if it's referenced. So if you need an expert's report, that probably goes after the applications, before the exhibits, depending on the type of application. Then cost schedules. In terms of pagination, it's not necessary to physically paginate a electronic bundle. A PDF itself will have page numbers, and as long as everybody is going to the right page, if you paginate it but not paginate the case summary, then everyone's a page off, and that makes things unnecessarily complicated. I'll post my suggested examples of documents and which order they can go in the description for this video. If there's any questions, comments, just leave them below. Send them to the email in the title page. I hope this was helpful.